And the 4 people. So.
Yeah, of course.
Okay. Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us my partner Mr. David Nachman. David, welcome.
Thank you, Michael. Nice to be here.
Very, very hot subject. All of you I know are waiting to have a complete detailed update and information on the Dreamers program. We have been, David and me have been talking in the past when the program was just announced, and we said that we will be getting more detailed information and the forms, and then when they want to start on August 15th. And since the previous programs, it has been a while, all the developments that have taken place, the forms have been published, they are available on the website, all the detailed information is available, and we already started filing the applications for those who qualify. But this is a very complex subject. I mean, a lot of people, this is something I want to say, thinking of doing in the end, but I'm bringing this from the front. Why is it important to explain to our viewers that I have got information that we already thought that may happen. Every time there's a new program, there are people, greedy people, there are agents, unscrupulous, unfortunately, even some unethical lawyers that they are not interested in doing the thing right, or giving all the information correctly, just somehow to get the money, and then problems come in, then they come to us, and sometimes we can help, sometimes it's too late to do anything. So with that word, I'm going to ask David to explain to you about the going forward on this program. Since we talked last time, they have already come up with the right forms. You can explain what the forms are, what the latest instructions are, and other information, then we can discuss more on that.
Great. Actually, Michael, what we did is we prepared a couple of slides for our viewers. The first slide here is a slide that explains exactly what the program is. It's called, they've actually given it a new name. We refer to it as Dreamer Act because specifically it kind of comes out of this prosecutorial discretion announcement that was made on June 15th. And then, of course, as we got closer to August 14th, when the more formal announcement and protocols were put into place, they referred to it as DACA, the Deferred Action and Childhood Arrival Program. So for our viewers who are on the internet looking up this program, you can find great information on the web by going directly to the USCIS website, which, by the way, has a very, very nice video on the program. It tells you step by step who qualifies, how to apply, and some of the other nuances of the program. So if you go to the USCIS website at www.uscis.gov, you can find that information. On your screen is some information that explains what deferred action is. And as we mentioned before, deferred action is a benefit that's been around for a long, long time. It's not something new, but what it is that they've basically decided that they're going to apply this deferred action benefit to individuals who are dreamers, who meet certain parameters. And so the parameters for an individual that they've entered the United States before 16 years of age, that they haven't reached 30 years of age, etc. Those are all also on your screen. There's a slide that explains not over 31 years of age. Yeah. So these parameters.
But let's talk about all the requirements. That's the most important thing they want to know. Who can apply? So first thing, as you said, they entered the U.S. before the age of 16.
16, correct.
Number one.
Yes.
Number two, on June 15th, 2012.
That they are not 31 years of age.
Correct.
Okay, so they're still 30 years of age.
And they have resided continuously for 5 years.
Since June 15th.
As of June, yes.
As of June 15th, 2007. Okay, that they don't have any felonies. They don't have any significant...
Serious crimes, you can say.
Well,
that.
Yeah, but significant misdemeanors, because yes. It's really important to understand this concept of significant misdemeanors, because it's not really in the law. There's no definition of
I would suggest that any of the viewers, that question comes to, in the filling of the forms, something like that, I think, is a good idea to consult an experienced immigration attorney to see whether this particular offense is significant or not significant.
That's right.
For the purpose of applying.
That's correct. Yeah. So,
And also, don't forget, the requirement is that you must have done a high school or a diploma, or you must be presently going to the school.
presently enrolled
And
in a program.
interestingly,
right.
David, and you know that this is okay to do it. A lot of people don't even think of that. There's one case that came in that he never did a diploma or high school or nothing. And right now he's working and not gone to school. I say it doesn't say that you must have been before only. It also says you may be currently. So the option to do is that that person can go to school, join the school now, and he has a school ID, is actually going to school, and maybe it may take a month or so or 2 more months to do that. But then when he's applying, he says, yes, I am currently going to the
Correct.
school.
As long as they are currently enrolled, that's what they're talking
Correct.
about. So if the individual is currently enrolled in a GED program
Right.
or currently enrolled in a language studies program with the expectation that that language studies program, they're going to determine when the person applies for an extension whether or not it was a logical progression toward getting the degree or progressing in their educational area.
How about somebody that the previous deportation order,
Yeah.
he is in the deportation proceedings, he got a voluntary departure. So some people think that that's not for
Right.
us.
Well, again, every person is in a different part. There are a couple of things that you
Yes,
just actually that was sort of a compound question.
Of course,
But the first part of that is if you have a final order, that doesn't matter. If you're still here, you can apply. If you don't have status and you meet the other parameters, you can definitely apply. There's nothing to preclude you from applying for this discretionary benefit. If you have an individual who is taken voluntary departure, if the person is in proceedings and taken voluntary departure, it seems that the way you would do that is you would make a motion you'd make a motion before the court to reopen the case and then to bring up this request for this benefit within the proceedings. So absolutely.
Let me ask you a couple of more questions. Will these people who are, first of all, let me go back to what you're explaining. There's no path to get a green card in this particular policy.
That's correct.
Let me just explain you that before that
It's not a form of valid status.
It's not,
in the United
first of all, the
States.
legislation, only Congress can do that.
That's right.
Because President Obama administratively can have a policy decision. And that's what he very smartly did. Because this is nothing new. Does he have the authority to grant deferred action? Yes. There's already an existing provision in the law.
So it's not a new program. It's been around forever. Right.
But very limited. Extreme hardship
That's
was.
correct.
So very smartly he said, well, all these 1.7 million students, I believe that they are causing extreme hardship. They cannot have a driver license. They cannot have a social security number. They cannot go to college. Right. So I believe that they are in that category. And he opened that door of deferred action, which is a very nice thing to do, and we really appreciate that. But it doesn't have any path. Hopefully what we are saying going forward, that after the elections, hopefully there may be some movement, maybe the Congress will pass a DREAM Act. Then all these people who are getting a deferred status now.
It's our hope that it might become permanent. Some of the unanswered questions, obviously we say that every cloud has its lining. So some of the downsides, which are really troublesome right now, there are a couple of things. One is that we don't have a whole lot of guidance right now on these crimes that could potentially affect an individual's ability. So as Michael pointed out before, it's really, really important to ensure that you take a look at the whole background, any interface at all that you've had with law enforcement. It's important to do an analysis to see. Number two, which is also really important to do, take a look at what the states are doing, because apparently the state of Arizona passed a proclamation which says that they're not going to be granting driver's license to individuals who are beneficiaries of the DACA program. And that's going to be troublesome, and that raises a constitutional issue in the United States. And it's highly likely in the fall that there's going to be a constitutional battle again between
I think this matter is going to go to the Supreme Court, because this is a big issue is that there's a federal law. Immigration is a federal law.
Right.
And states cannot do anything to contradict that law, to question that law, to bypass that law.
Right. Well, basically what it is that under the Constitution, immigration was deemed recently by the Supreme Court in the Arizona decision as being a federal issue. So it's the federal guidelines are what's going to regulate immigration. And now the states are basically saying, okay, just because you become a beneficiary of DACA does not mean that we're going to grant driver's license. So I think you're right. It's going to go to the Supreme Court, and there's going to be an argument.
Two more quick questions. Employment authorization. Now, let's say somebody applies for the deferred status. Can he also apply for employment card?
Well, actually, the way the rules work, and it's pretty clear.
Should file together, right? Yeah.
It's pretty clear in the video, which again we would recommend that you take a look at. The video on the USCIS website clearly states that you should submit your I-821D form simultaneously with an I-765 form. Be very, very careful to ensure that the I-765 form that you're submitting is the most recent one. So it's going to be dated August 15.
It's a new form. Yeah.
Right, August 15, 2012, because they promulgated a new form. If you use the old form, the case will be either denied or be returned, and you don't want that to happen.
And there's also a worksheet to be completed.
Correct.
Why you need the work authorization, the necessity.
Right, it's an I-765WS. It's a worksheet that needs to be submitted. It's very, very important to ensure that you put on that why the individual needs to work, although it's almost inherent in the application as to why the individual needs to work. Something very important that we've noticed in the rules and everything that's been coming out about DACA, make sure you include 2 passport photos. It doesn't say anywhere except on the I-765 instruction sheet, include 2 passport photos. If you don't, it's going to slow the application down.
Two other things let me talk about. AR11.
Yes.
This is the form that when you change the address, move from one location to another, you must file that form with the Immigration Service.
Correct.
And this question may come in, probably going to come in. And if somebody has not done it, they could deny that application.
Well, not only that, they also say that there's no right to appeal or to make a motion to reopen this case unless you filed the AR-11 properly and the government screwed up by sending the documents to the wrong address. That does give you an ability to contact the USCIS to get a review of your previously denied case.
And there is no permission to travel. These people cannot travel. If they travel outside, even with the advance parole, if they travel in, then that says you cannot travel, then you may incur a unlawful presence.
Well, once the I-821D is approved and the individual is approved for DACA benefits, they do have the ability to apply on an I-131 for a travel document. However, as Michael rightfully points out, you got to be really careful to ensure that if an individual has accrued unlawful presence, that they can travel outside the United States, because DACA benefits do not eradicate the 3- and 10-year bars that might apply to the individual.
So that's a complication, and we don't advise. We cannot advise.
Right. But
even if you get advance parole.
I saw a girl the other day who's a potential beneficiary of the DACA program, the Deferred Action Program, and she's 16 years old. And so her parents were illegal, and they were sitting in the room, and I explained to her that if she gets DACA benefits, then she can actually apply for the travel document, and she can travel outside the United States because she will not have accrued unlawful presence, because she was able to obtain the DACA benefits before unlawful presence accrued to her because she's under 18 years old. 100%. So it's a very limited group of people, but it's still very, very nice that they have that opportunity because they can go outside the United States. Yeah.
David, we have to talk a lot about this, and most important thing are documentation. So there are requirements, age 16, 31, high school, and necessity and everything. So we don't have time today. This program, we have to come to a conclusion. But we promise you, next program will fully devote to giving you all the detailed information of what kind of documents that you will need to submit, so that you can go around, look for these documents, and make sure that every application is properly supported by the documentation. Because there is a chance, most of the cases they may not call for interview. There is a possibility that they will be calling, whether it's random, whether it's based upon the information coming to them, whether background or security grounds or whatever the reasons, they may be calling for the interview. So we will discuss at more length in our next program. Don't forget to watch us again next week, Saturday.